Major shakeup of federal gun rules is now in motion. 34 proposed changes on gun policy.
Not everyone is on board.
The ATF just announced 34 new proposed rules, and I mean all at once dropped right after Robert Sakata was confirmed as the new ATF Director. 34. That is the single biggest regulatory action this agency has taken in modern memory. Now, before you panic, here's what you need to understand. The majority of these rules are actually designed to roll back overreach, modernize outdated requirements, and in several cases restore rights that never should have been taken from you in the first place. I'm going to break down exactly what these rules mean for you, group by group, because the details here matter enormously. Alright, so why should you care? Because if you own an AR pistol with a brace, if you've ever bought a firearm from an FFL, if you own NFA items like suppressors or short-barreled rifles, if you've ever traveled across state lines with a firearm, or if you've ever filled out a Form 4473, and that's basically every single one of you, these rules touch your life directly. Here's the critical thing to understand up front. None of these rules are effective yet. Not one. Every single one of these 34 proposed rules has to go through the federal notice and comment rulemaking process under the Administrative Procedure Act. That's 5 U.S.C. Section 553 for those of you keeping score. That means the rule gets published in the Federal Register. There's a public comment period of at least 30 days, sometimes longer, and then the agency reviews those comments before issuing a final rule with an effective date. That process is your opportunity. If there's a rule in here that doesn't go far enough, or if there's language buried in the details that concerns you, public comment is how you make your voice heard. And I'm going to tell you right now, there are a couple of these rules where your comments are going to matter a great deal. These 34 rules are organized into 5 groups: repeal, modernize, reduce burden, clarify, and align. Let's walk through the most significant ones in each category. First and most obviously, the repeal of the pistol brace rule. That's the rule that reclassified millions of braced pistols as short-barreled rifles overnight, turning law-abiding Americans into potential felons with the stroke of a pen. Every single court that has reviewed this rule has vacated it. The Fifth Circuit struck it down. The Sixth Circuit struck it down. District courts across the country struck it down. This repeal is long overdue, and frankly it should have happened on day one, but it's happening now, and that's a good thing. Second, a revision of the engaged in the business definition. Now this one requires some context. Under the Bipartisan Safer Communities Act, that's Public Law 1170-159, passed in 2022, Congress changed the statutory definition of who is engaged in the business of dealing firearms. The previous administration's ATF then used that statutory change to write an incredibly expansive rule that essentially said if you sell a single firearm for any amount of profit, you might need a federal firearms license. Courts have had serious problems with that interpretation. The revision here is necessary, but, and this is important, the underlying statute still has problematic language. So what the revised rule actually says when we get the text is going to matter enormously. Watch this one carefully. Third, revising the machine gun definition in response to Garland v. Cargill. That's the 2024 Supreme Court decision, decided 6-3, that held bump stocks are not machine guns under federal law. The court said the statutory definition of a machine gun requires a single function of the trigger firing multiple rounds, and a bump stock doesn't meet that definition. This proposed rule aligns ATF regulations with that decision. In other words, the ATF is being told by the highest court in the land what the law actually means, and now they're updating their rules to reflect it. That's how this is supposed to work. Here's where things get really interesting for the everyday gun owner. Revising Form 4473, that's the firearms transaction record you fill out every time you purchase a firearm from a dealer. 2 big changes here. 1, allowing electronic submission of the 4473. 2, and this is huge, extending the period that a NICS background check remains valid. Right now, if your background check comes back delayed and you're in a state with a statutory waiting period, you can end up in a nightmare loop. You wait out the waiting period, you get the approval, but by the time you can get back to the store, the background check has expired, and you have to start the entire process over. Extending the validity window fixes that problem. This is a practical, common sense change that directly benefits you. Allowing FFLs to maintain electronic records. Believe it or not, there are federal firearms licensees in this country still keeping handwritten bound books. Physical paper records of every transaction. This rule would allow them to modernize. Now I know what some of you are thinking. Electronic records make it easier to build a registry, and you're right to think about that, because it connects directly to the next rule. replacing indefinite retention of 4,303 records with a defined retention period of 20 or 30 years. Alright, let me be very clear about this one. Under current practice, the ATF has been collecting and digitizing out-of-business dealer records, building what is functionally a federal firearms registry, something that is explicitly prohibited under 18 U.S.C. Section 926A. Setting a defined retention period is a step in the right direction. The ATF is getting warmer. But 20 to 30 years? Come on. If you bought a firearm legally 20 years ago, why does the federal government still need a record of that transaction? Group 3. Reduced burden. NFA items. If you own suppressors, short-barreled rifles, short-barreled shotguns, or any other NFA-regulated items, pay very close attention. Repealing interstate NFA transport notice requirements for trips under 365 days. Currently, if you want to take an NFA item across state lines other than a suppressor, you need to file ATF Form 532020 and wait for approval before you can legally transport it. Under this proposed rule, any trip under a year wouldn't require notification at all. And for permanent moves, you'd submit the form, but you would not have to wait for approval before transporting the item. You file it and go. That is a massive, massive change for anyone who travels with NFA items or has relocated to another state. Joint NFA registration for married couples. Right now, if a husband and wife both want legal access to an NFA item, the standard approach is to set up a gun trust, which means lawyer fees, paperwork, and complexity. This rule would allow married couples to jointly register NFA items without a trust. Now, the gun trust lawyers aren't going to love this, but for married couples building an NFA collection, this is a significant cost savings and a real practical benefit. Removing the CLEO notification requirement. That's the Chief Law Enforcement Officer notification that was already largely eliminated by previous rulemaking, but this would formalize and clarify that it is no longer required across the board. Clarifying that common, reasonably necessary activities during travel are protected under FOPA, that's the Firearms Owners Protection Act, 18 U.S.C. Section 926A, specifically the Safe Passage provision. Right now, there are states, and you know exactly which ones I'm talking about, New York, New Jersey, Massachusetts, Illinois, California, that interpret safe passage to mean you must be driving straight through without stopping. If you pull over for gas, stop at a diner, or God forbid get a hotel room because you're too tired to drive, some of these jurisdictions will arrest you and charge you under their state firearms laws. This proposed rule would clarify that reasonable stops during travel are covered by federal safe passage protections. If this rule goes through as described, it would be a genuine game changer for anyone who has ever driven through a hostile state with firearms in the trunk. Clarifying that persons receiving assistance in only one functional area, like financial management, would not on that basis alone be considered prohibited under the mental health disqualifier. This is the fiduciary issue. The VA and other government agencies have been using the appointment of a financial fiduciary, someone to help manage your money, as a basis to strip veterans and others of their Second Amendment rights. If you need help balancing your checkbook, that does not mean you are mentally incompetent to own a firearm. Period. This clarification is long overdue. A few more worth mentioning quickly, clarifying when a transaction constitutes a straw purchase, defining willfully for firearms violations, which is a big deal because the Bipartisan Safer Communities Act essentially watered down the willfulness requirement to the point where accidental conduct could trigger criminal liability, and removing former Soviet countries other than the Russian Federation from the list of nations from which the ATF denies import applications for firearms and ammunition. That last one could have a significant impact on the firearms import market, though. How significant remains to be seen. Let me be straight with you. Is this everything we want? No. The 4473 retention period of 20 to 30 years is too long. The engaged in the business revision depends entirely on language we haven't seen yet. And the safe passage clarification, while welcome, is only as strong as hostile states' willingness to comply with federal preemption. And historically, states like New York and New Jersey have not exactly been eager to respect your rights regardless of what federal law says. But is this a dramatically different direction than the previous administration? Absolutely. And it's not even close. Think about where we were 2 years ago. Steve Dettelbach's ATF was cranking out rules designed to criminalize as many gun owners as possible. The pistol brace rule, the expanded engaged in the business rule, the bump stock ban. Now you have an ATF director whose first official act is to propose 34 rules, the majority of which are designed to repeal overreach, reduce regulatory burden, and restore rights. That is not nothing. That is significant. But the devil is always in the details, and we do not have the final regulatory text yet. When those rules are published in the Federal Register, that's when the real analysis begins. So here's where things stand right now. 34 proposed rules have been announced but have not yet been published in the Federal Register. Once published, there will be a minimum 30-day public comment period for each one. None of these rules are in effect today. Your pistol braces are still in legal limbo under existing court orders. Your 4473 records are still being retained indefinitely, and FOPA safe passage is still being ignored by hostile states for now. When these rules start hitting the Federal Register, we will be going through them line by line. The ones that matter most to you. The 4473 retention, the engaged in the business revision, the safe passage clarification, those are getting full, dedicated breakdowns. In the meantime, your action item is simple. Be ready to submit public comments when those comment periods open. That is your voice in this process. Use it. That's it for today, folks. See you in the next video.